thank you very much for joining us today. A very warm welcome to you all, and thank you for taking the time at what is a very busy time for all of us to connect with us. We are delighted to be hosting this webinar today jointly with Michael Page, who we are partnering with on this event. And the purpose of this session is really to bring our clients, communities and colleagues together to run through some of the employment law issues that are arising in relation to returning to work and getting your staff back into the workplace. We will have time to take questions during the course of the session. If you would like to ask questions, please submit them via the Q&A function on your screen, and we will answer them at the end. We will be recording this event, and we will send the recording out afterwards. Towards the end of the webinar, we will ask you to complete a short feedback survey, so please keep an eye on the Q&A box for that link. So moving on, I'd like to introduce your panelists for today. For those of you who haven't met me, my name is Kirsty Eyre. I'm an employment law partner at Irwin Mitchell, and I head up our employment law team in Sheffield. And with me today is Emily Weston, who is a solicitor in our team, and both of us have been very busy over the past few weeks, as you would expect, dealing with queries linked to coronavirus. So moving on to the next slide, I'd like to just recap briefly on the timeline that has led us to where we are at the moment. So 23rd of March was D-Day for many, when many businesses had to close their doors and we went into national lockdown. The government has never actually given any direction to say that non-essential businesses have to close, but certainly many did, and many staff have been furloughed. Last month, on the 13th of May, there was a change in approach, and we were actively encouraged to return to work, but still working from home wherever possible, and workplaces have been allowed to open. On the 1st of this month, schools and colleges were encouraged to open for some pupils, and outdoor markets and car showrooms have been allowed to open, and then from next Monday all other non-essential shops are being allowed to open. So moving on to the next slide. Thank you. What do you need to do before you can reopen? Well, no business should reopen unless it is COVID secure, which is a new buzzword. What does that mean? Well, you have a duty to take all reasonable steps to ensure that your staff work in a safe environment. And if you identify risks, you must take steps to reduce those to the lowest practicable level. You don't have to eliminate risk altogether. It's recognised that that's just not possible. But as a very minimum, you should check the HSE website, look at the guidance. They've got guidance on there for carrying out risk assessments and preparing workplaces to reopen. So you should be carrying out a COVID risk assessment before people are coming back into the workplace, and before you open your doors to customers if your doors have been closed. So what should a risk assessment look at? Well, it should consider what work activity or situations might cause the virus to be transmitted at work. You should consider who could be at risk, and specific, there will be certain groups that are more vulnerable than others, and I'll come on to talk about those. Take a view as to how likely it is that somebody could be exposed to the virus at work, and then look at what you can do to remove the activity or situation that could cause transmission of the virus, or if this isn't possible, control the risk. If you've got an internal health and safety team, then use them, or you could look at getting an external expert in health and safety to come and do the risk assessment for you. The government has produced specific recommendations for different sectors on how to reopen, and on the slide I've set out the different sectors that there is specific guidance for. There is a lot of similarity between the guides. The basic rules are, if you can social distance at work, you should do so. But if the nature of the workplace is such that it's not possible to social distance, you can only reopen if you put in place suitable measures to control the risk of transition. This might include putting barriers in shared spaces, creating shift patterns so that you have the same workers working at the same time every day that they're in work, so creating almost a mini bubble within the workplace. And if your business uses shared spaces, for example, lifts, if you're in a building that you share with other occupants, you'll need to work with those other occupants to identify and then minimise the risk. We have seen some examples of good practice already with supermarkets, for example, that have remained open throughout the crisis, with barriers at tills, one-way systems, limiting the number of people on the premises at any one time, and limiting the numbers of people who can, of customers who can come in as well as staff. So I think we're all going to have to take quite a practical and pragmatic approach. Moving on to the next slide, when it comes to risk assessments, there are two sets of regulations that you need to take account of and that you should ask your health and safety advisors to cover off with you. In essence, these regulations are designed to enable you to develop, maintain and promote measures that ensure health and safety at work, and then to check how effective those measures are. If you recognise a union and you've agreed to collectively consult about health and safety issues, then you must discuss your proposals to make your workplace safe for staff to return to with the union. If you don't have union health and safety representatives, then you should consult your employees directly, either as individuals or by electing workforce elected health and safety representatives. Moving on to the next slide, consultation about returning to work. How long do you need to consult with your health and in relation to health and safety before people return to work? Well, there are no minimum periods of time prescribed in the legislation. The legislation, rather, one might say unhelpfully for employers, just says you've got to consult in good time before you reopen. So that will involve giving enough time for you to provide information to the reps about what you're proposing to do in your risk assessments, and give them the time to consider it, and then come back to you with any questions or suggestions. So you should allow, I would say, at least a week or 2 weeks in practice for this to happen. Now, consultation doesn't mean that you have to agree. You should try and agree with the reps if you can about the health and safety measures that you're going to take, but ultimately you as the employer are responsible for making the final decision. If you don't comply with the regulations and the obligations to consult, just a slight word of caution is that it is technically a criminal offence, and health and safety inspectors, both from HSE and from local authorities, may enforce the regulations where there is no evidence of consultation. If individuals or the union raise concerns about returning to work, then listen to those and seek wherever possible to try and resolve them and find a practical solution. For example, if somebody is shielding because they are particularly vulnerable, could they continue to work from home if they have already done so? If you have 50 employees or more, then you must publish your risk assessment on your website once you have done it. Moving on to the next slides, travel. We'll all have seen pictures of crowded buses and tubes. Fortunately, not so much in our neck of the woods, but certainly in London. And it is clear that social distancing is very difficult for those who rely on public transport to get to work. And of course, there will, from next Monday, be an obligation to wear face masks or face coverings on public transport, and the hope is that that will help to reduce the transmission of the virus on public transport. Normally, when you're carrying out health and safety risk assessments, you don't have to assess the risk of travelling to work. However, in the current circumstances, HSE guidance does cover travel, and I think you should be covering travel to work where possible in your risk assessments. Firstly, because of the health and safety legislation, also because there is a common law duty of care for people to take reasonable care for health and safety of employees. If you don't do that, then that could be a breach of the duty of trust and confidence, which could give rise to constructive dismissal claims if staff are brave enough to resign and bring claims in the current circumstances. And the other thing to take account of is that there is a duty not to subject employees to any detriment, such as withholding pay, for example, or dismissing them if they take action because they are concerned about a serious and imminent danger to their, to their health and safety, or to the health and safety of somebody else. And Emily's going to come along and talk about that in a little bit in more detail. So HSE guidance says employers should think about identifying, can people travel alone in their own transport to work, and people should be encouraged to do so, as to maintain social distancing. So can people walk, cycle, run, drive in their own cars to work to maintain social distancing? There's also suggestions about staggering arrival and departure times so that there's not an influx of people into the building, for example, at 9 o'clock in the morning and then the other way at 5 o'clock in the afternoon. Can you stagger start and finish times if you have a pinch point that entry to the building that everybody has to go to? You should be providing hand washing facilities, running water, soap and paper towels at all entry and exit points, so that people can wash their hands on arrival and on leaving the premises. If you can't provide running water, then hand sanitizer should be made available. Anyone who can't walk, cycle or drive to work is likely to need to use public transport. If this is overcrowded, it will increase the risk that staff become infected and in turn possibly affect other members of staff. The government has produced safer travel guidance for passengers, which asks users to consider all other forms of transport before using public transport. Where there's no alternative, people are advised to maintain social distancing. If they can, wait for the next bus or train if their train or bus is already full, to consider travelling off peak, wearing a face covering and avoiding eating and drinking whilst travelling. So I think you should be looking at finding out how staff will travel to work, and encouraging them to travel by themselves if they can. There's no reason why you couldn't look at car sharing, but if you do look at car sharing, then I would suggest that you ensure that people car share with the same person or people every time, that they wear face masks in the car, and that there are wipes, antibacterial wipes available so that the car can be cleaned after the those who aren't who don't own the car get out of it. Moving on to the next slide, risk assessments must cover particularly vulnerable people, such as pregnant women. Pregnant women, if there is a risk to them of returning to the workplace and you cannot reduce that to an acceptable level, then they have a right to be given alternative work, and if that's not available, then they have a right to be suspended on full pay until the workplace is safe for them to return. Your risk assessments should also cover those who are required to shield and BAME members of staff in light of the evidence that those from Black and minority ethnic groups are more adversely affected by the virus than others. So moving on, looking a little bit at the future, what is your organisation going to look like? Unless you're in the fortunate position of being able to pick up where you left off when we went into lockdown, you're likely to need to continue to reduce payroll costs while you assess what your organisation is like. If you aren't going to need as many people over the next few weeks and months, there are a number of options. Continuing to use the furlough scheme, changing terms and conditions of employment, for example, to reduce pay, to reduce working hours, to put people on 0 hours contracts, making redundancies, and offering unpaid leave or sabbaticals. So moving to the next slide, furlough, the scheme has now been extended to the 31st of October this year. It will continue to apply in its current form until the end of this month, but from today you won't be able to furlough anybody who hasn't previously been furloughed. So if you've got people who you have furloughed in the past who've come back to work, then they can go on furlough again for a minimum of 3 weeks, but anybody who hasn't yet been furloughed can no longer be furloughed. From next month, from the 1st of July, there is going to be more flexibility in that workers will be able to return to work on a part-time basis, so you could have them in work 1 or 2 days or however many days a week you wanted them in, and then they could be on furlough the rest of the time. So that should hopefully give you some flexibility to bring people gradually back into the workplace if you're able to do so. Moving to the next slide, from August, you will have, as employers, to start contributing to the cost of furlough, and the cost is being increased gradually. So from 1st of August, you have to pay employers NI and pension contributions. From the 1st of September, in addition, you will have to pay 10% of the employee's wages, with the government contribution reducing from 80% to 70%. And then from 1st of October, your contribution will have to go up to 20% of wages. Interestingly, a quarter of company directors surveyed by the Institute of Directors say that they won't be able to afford even the 20% of the furlough scheme if asked to do so. Are you likely to need to make redundancies? If so, you need to think about when you're going to do that, whether you're going to wait until the 1st of November when the scheme comes to an end, or start consulting now. The current guidance on the furlough scheme indicates that you can start consultation whilst people are on furlough, and you can carry out consultation meetings with them whilst they are on furlough. Moving to the next slide then, asking staff to return to work. How much notice do you have to give them? Well, that is really up to you, unless you specifically set out in the letter that you sent to them when they were put on furlough how much notice they would be given. Then the question is just reasonable notice. Taking account of the fact that people may still have children at home, childcare issues that they need to resolve. So I would contact them as soon as you can and tell them when you want them to come back, how you want them to come back, whether it's full-time, part-time, and then give them the opportunity to ask any questions or raise any concerns. If they are worried about returning to work, for example, because they may be living with somebody who is shielding in their household, or they themselves may have particular health concerns, then you need to try and find a practical solution with them. If they can work from home, then they should be allowed to continue to work from home. If their job can't be done from home, then consider alternatives such as, are there any alternative roles that they could do? Could they swap duties with somebody else for a period of time? Could they change their hours of work so that they're not travelling into the office at busy times, and they're working in a part? Could you make them work in a part of the workplace where they will have minimal contact with colleagues? Could you offer face coverings, PPE? You need to be exploring all of these options with them. Moving on to the next slide, what if people refuse to return to work? How do you deal with that? And the evidence suggests that many people are concerned about returning to work and sending their children back to school. You need, first of all, to find out why are they concerned to return to work. Are they vulnerable themselves or living with somebody who is vulnerable or shielding? Do they have a disability? Are they pregnant? Do they have childcare responsibilities? All of these will place additional obligations on you as the employer. Or if it's just a worry about returning because they've been cocooned in their home for the last few weeks, then ask them. Then you might want to share with them the risk assessments that you've carried out, the steps that you're taking to address their concerns, and look at the practicalities such as assigning them to a different role, allowing them to continue to work from home. If none of that is possible, then you may have to consider putting them on unpaid leave, or potentially dismissing them. You would need to be very careful before dismissing somebody in these circumstances, though, because there are a number of legal implications of doing so. And Emily is going to run through those now, so I'm going to hand over to Emily.
Thank you, Kirsty. Good morning. Yeah, so I'm going to talk about health and safety rights in respect of those that are understandably worried or scared to return to work, particularly because they don't think that it's safe to do so. And they are protected in law by the Employment Rights Act. It's sections 44 and 100, which essentially creates a right for employees not to suffer detriment or dismissal where they reasonably believe that there is a serious and imminent threat of danger. And that could apply if they are refusing to return to the workplace, if they've left. So if they come in, you know, they think it's not safe once they've got there, then they've left. or if they've taken appropriate steps to protect themselves or others. That can also possibly apply to the wider group of workers, so it is a really wide right. And it's really important that employers do consider this carefully before taking any action in respect of employees that are perhaps refusing to come into work. And it can also apply if you're thinking of taking action like suspension or pay deduction, so any detriment that employees could be subjected to, they are effectively protected from that by this legal right in the Employment Rights Act. And the risks are, if this provision is breached, that if you do dismiss somebody and it's later determined that it is in breach of this provision, that could be deemed an automatic unfair dismissal. And employees don't need a qualifying period to bring that type of claim. So in an ordinary unfair dismissal claim, employees would need to have 2 years service, but in an automatic unfair dismissal claim, they don't need to have 2 years service. And compensation in respect of that claim, that type of claim, can also be uncapped. And then the other risk with subjecting employees to a detriment is that individuals could choose to resign and claim constructive unfair dismissal. So it's really important that employers consider the points that Kirsty discussed earlier in respect of risk assessments and making sure that the workplace is safe. And that they've done everything that they can do and that is necessary in the circumstances. In terms of what we mean in respect of that legal right by there being a danger in the workplace, that needs to be an actual danger, and that is judged objectively. And in order to be protected, the employee needs to have a reasonable belief that their workplace poses a serious and imminent threat to them or to others. And when we refer to others, that could include members of the public or that their own family. So again, perhaps if they've got a vulnerable person at home that they are seeking to protect. In terms of what we mean by imminent, obviously we all know that sadly COVID-19 is a deadly disease, and it is possible that some employees might argue that the risk is always going to be imminent while ever the pandemic is ongoing, and that's supported in part by the alternative stage group, who argued that easing the lockdown restrictions without having a rigorous testing and trace system was dangerous and would increase the risk of local epidemics. And anybody, as I said, that's living with somebody who's shielding or is vulnerable may be genuinely concerned that they may pick up the virus from work and take it home, which poses a serious risk to that vulnerable person that is at home. You might disagree with your employee's assessment, so they may feel that it's unsafe, but you might feel that as an employer that you've done everything that you can to mitigate against the risks. But ultimately, the legal test comes down to the employee's reasonable belief. So provided that they do have a reasonable belief, they will still qualify for protection under this legislation. So we would suggest that the more that you can do to communicate to staff about the measures that you have put in place, about your risk assessments and all the measures that Kirsty discussed earlier, the better. I think it really is a communication piece and a matter of trying to reassure employees as far as possible that you have put precautions in place. And obviously, if anybody does have specific concerns, try and talk to that person about their concerns and address them and make adjustments for them as far as you possibly can. The case law in this area is not particularly helpful because obviously this is a novel situation, and the law is intended to apply to extreme circumstances of danger. In the past, that's been applied in different circumstances. So we don't yet know how this is going to be interpreted by employment tribunals. So it's really a sort of wait and see in terms of how the case law on this area is going to progress in relation to COVID-19 in particular. So again, from our perspective, it's just trying to do whatever you can as an employer to reassure employees, and as it says at the bottom there, try not to be a part of the case law that's inevitably going to come on this point. One point that employers have, we've been asked quite a lot about recently, is whether it's possible to change employees' terms and conditions, and a lot of employers have already done this. So in terms of perhaps reducing hours and reducing pay, or asking employees to carry out different duties for a temporary period of time. And we've had a lot of questions about how to do that and what the relevant process is. And the starting point is to consider whether there is a contractual clause within the employment contract that allows for variations to be made. The ACAS guidance recommends considering specifically what you can change. So if there is a clause in the contract, what does that allow you to change? If you need to give notice in respect of any changes, and what process needs to be followed. And if you are relying on a clause in an employment contract, that clause needs to be clear and unambiguous. Generally, any ambiguity in a contract will be interpreted against the employer, so it's important to make sure that it is clear. And general flexibility clauses usually won't be enough. So it's important to check all of those things if you are trying to rely on a contractual clause. Most employment contracts won't have a clause that will allow you to do things like reduce salary and reduce hours. So in most circumstances, employers are having to seek agreement. The risk of just making the change rather than going through a process of seeking an agreement and consulting is that it could lead to claims for breach of contract. If an employee's got more than 2 years service, they could resign and bring a claim for constructive dismissal, and possibly discrimination, indirect discrimination claims, if the changes disproportionately impact on a particular group of employees. And then at the bottom there, even if you do have a contractual clause, you do still need to act reasonably, and the key is to maintain trust and confidence with the employee. Otherwise, like I said, there would be a risk of those legal claims that I've just talked about. In terms of if you haven't got a contractual right to vary terms and conditions in the employment contract, and if we could just flip to the next slide, please. This is when you would need to seek agreement and try to agree the changes with staff. If you've got a recognised trade union, then generally you would need to consult with the trade union in respect of any changes, if those changes are subject to collective bargaining provisions. Otherwise, you would need to consult with the employee directly. The ACAS guidance in respect of this suggests that the employer should explain the reason behind making the change, invite employees to talk about their concerns and suggest ideas for alternatives. Listen to employees' concerns and consider their ideas, and do everything possible to try and resolve any concerns that the employee may have about the change. If changes are agreed, they then need to be confirmed in writing, and that's a requirement by under Section 1 of the Employment Rights Act. Obviously, in a situation where you are trying to reduce somebody's pay or reduce their hours or change their duties, it might be difficult to reach agreement on that. And in that case, there are a couple of options which should be only really be considered as a last resort due to the legal risk, but it may be possible to dismiss an employee and then attempt to re-engage them on new terms. But if you are considering that, you first need to think about whether you've done everything possible to try and reach agreement with the employee. So, as I said, go through that consultation process, try and address any concerns that they may have. Consider whether the changes are absolutely necessary, and consider what the risk of making the changes to employee engagement and morale. And then also consider what the legal risk is in respect of dismissing and re-engaging. Obviously, if you've got somebody that's got more than 2 years service, they may be able to bring an unfair dismissal claim. It's possible that this kind of dismissal may be fair, based on the potentially fair reason for dismissal of some other substantial reason, but it's quite a risky approach to take, so you do need to make sure that it's necessary to make the change and that can be justified for a genuine business reason before you make the change. Changes shouldn't actually take place if you are dismissing and re-engaging until the employee has been fairly dismissed and they can then be rehired under the new contract. And I think what's important in respect of any request to vary an employment contract is that the tone of communication is key. So you need to explain, as I said, why you might want to make the changes. Try not to use threatening language. And try and discuss and have a two-way consultation with employees as far as possible. Hopefully, most employees will want to keep their job. So if the alternative is redundancy, then hopefully you can use that two-way consultation process to reach some kind of agreement. Moving on to the next slide. Obviously, it's a very difficult time at the moment, and some employers unfortunately are having to consider redundancies, and it's important to consider when you are thinking about making redundancies how many employees are likely to be affected and whether the obligation to collectively consult is triggered. Interestingly, a survey from the Institute of Directors Lobby Group found that a quarter of the 1 million companies surveyed had indicated that they were considering making redundancies once the furlough scheme ends, which is a very sad statistic, but it's a sign of the times, I think, and we've certainly been getting quite a few queries about redundancies recently. So collective consultation is generally required where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. This applies where the reason for dismissal is not related to the individual concerned. So this could also apply to dismissals where you're trying to vary terms of a contract and you're thinking about dismissing and then re-engaging the employee on the new contract. So you need to consider in that situation whether collective consultation is required as well. The fact that you are proposing to offer re-engagement in that situation is effectively irrelevant for the purposes of determining whether collective consultation is triggered. So you do need to think about it in that situation. Depending on the number of employees involved, the collective consultation obligations would trigger the requirement to consult for a certain period of time, and that's generally 30 days if you are considering redundancies in respect to 20 or more employees, or 45 days if you're considering redundancies in respect of 100 or more employees. And there is a requirement to notify the Secretary of State of your proposals at the earliest opportunity by using a HR1 form. And it's important to consider when you actually start the collective consultation process, because, and I'll come on to this in a second, it may be that you need to elect representatives if you don't already have representatives elected that you can consult with. It's important to make sure that you build in the necessary consultation period. The potential penalties for failure to collectively consult are criminal penalties in respect of the notification to the Secretary of State, and also the claim for a protective award of up to 90 days gross pay per employee affected. So most employers are taking the cautious approach and starting collective consultation where they think it may be necessary to do so. Moving on to the next slide, in respect of problem areas in respect of collective consultation. As I said before, it may be necessary to elect representatives if you don't already have them in place. If you do recognise a union, you'll need to consult with union representatives, but otherwise, as I said, you may need to build in time to go through an election process. Generally, the law says that in order to make arrangements for election, those arrangements need to be reasonably practicable to ensure that the election is fair. And as far as reasonably practical, voting is supposed to take place in secret. And the election should be conducted to ensure that the votes can be accurately counted. However, I think that lends itself to the question of what is reasonable in the current circumstances, given that staff might be working from home or on furlough. We would suggest that where possible, you try not to cut corners with the process, and that you still conduct a fair election process as far as possible. You need to decide first how many representatives you might need. So consider how many employees are going to be affected and how many representatives it would be reasonable to have in that particular situation. Perhaps you could consider asking for volunteers. And then you'd only need to hold an election if you receive more volunteers and there are spaces available. Those are just, some more creative solutions, I suppose, to try and conduct this process in this difficult situation. You also need to consider the practicalities of actually consulting with representatives in this situation. Employers have an obligation to allow representatives access to affected employees. So you need to consider how that's going to be done if people are on furlough. Are you going to use post, or are you going to use telephone conferencing or video conferencing services? And the employer is likely going to have to meet the cost for those services, so that all needs to be factored into the planning process when you are considering redundancies of this nature. The employer also needs to provide certain information to the representatives. So again, it's factoring time in to get that information to them, and thinking about how you're going to do that, and how you're going to get details to the representatives of all the potentially affected employees. There is a defence in respect of the failure to collectively consult, known as the special circumstances defence. It's mostly been applied where an employer has had to shut down business due to a sudden or unexpected disaster. So arguably that could be used here. But the furlough scheme has given employers some breathing space, at least up until the 1st of August. So our advice would be that you do the best that you can to comply with collective consultation obligations. It's unlikely going to be enough to just say that it's been too difficult to comply, and if it genuinely has been too difficult to comply, then you need to have justification and reasons for that. in order to rely on the defence. So we'd suggest that you do try to follow the normal process as far as possible. Moving on to the next slide. So employee representatives can perform duties without breaching the no work rule furlough conditions, as Kirsty touched on in her presentation. The government guidance expressly says that employees can do that, so we know that that is the case. And it also makes it clear that employees can't do anything which makes money or provides services for the organisation. And consultation obviously doesn't make money or provide services, so we think that it should be okay to continue with the process. In respect of the timing of redundancy and unfair dismissal, even if you have a genuine redundancy situation, you need to consider whether there are any alternatives to redundancy, and the existence of the furlough scheme may be relevant when you're considering whether there are any alternatives, as obviously that could be an alternative to either keep the employee on furlough or to re-furlough them if they've been furloughed previously. So that is something that you may need to consider during the redundancy process. It's probably a good idea to do that whilst the scheme is still open and if the employee is going to be eligible for it. But obviously it is a short-term solution, and that will be another factor to consider when you are considering that as part of a redundancy consultation process. We would suggest that you take advice if you're in that situation, because it's important that you consider all viable alternatives and make sure that you have a good reason as to why they are not appropriate if you aren't going to consider those alternatives. There is a useful redundancy process map available from ACAS that suggests that employers should consider whether the furlough scheme could be utilised. And we've already seen some arguments from unions who've argued that employers should be considering the furlough scheme. But ultimately, as it says on the slide, it will be determined by the employment tribunals in the coming years as to whether it's reasonable or not to consider the furlough scheme. Moving on to the next slide, if you do carry out a redundancy process and make redundancies, there's then a question of notice and notice pay. Generally, the usual rules in respect of notice will apply, so employees will be entitled to notice prior to being made redundant, and they'll also be entitled to redundancy payments if they've worked for 2 years or more. We believe at the moment that you can serve notice during furlough. However, there is a debate as to what notice pay employees will be entitled to if they are on furlough, as that's not covered expressly by the scheme. It's the law on this area is complicated, and it's not immediately clear, and ultimately it will depend on what notice the employee is entitled to, and in some circumstances it may be that you can base notice pay on their reduced furlough pay, but ultimately it will depend on the type of notice that they are entitled to under their contract. So what we suggest is that you take advice if you are in this situation and you're not sure on what to do. We also think that you probably can use the furlough grant towards notice payments. Again, that isn't covered expressly by the scheme at the moment, but there's nothing in the scheme that suggests that that's not possible. Moving on to the next slide, redundancy pay. The employee guidance, again, doesn't mention this at all, but it does expressly state that grants cannot be used to substitute redundancy payments. There's also an argument that using grant funds to pay notice is analogous to holiday pay, and the government recently made it clear that employers can use furloughed grants to meet the holiday pay of individual employees, which is partly why we think that it is possible to use the grant to subsidise notice pay. The safest course of action in relation to calculating redundancy pay is to calculate it based on the employee's pre-furlough salary. However, it may be possible to base it on the furloughed salary. The issue is that it's likely to be unpopular with staff, and it could lead to employment tribunal claims, which is why we'd suggest using the pre-furloughed salary. And then moving on to the next slide, just a quick to-do list, just to sort of sum up what Kirsty and I have covered. So firstly, conduct a COVID secure health and safety risk assessment. Consider the impact of returning to work on those who are particularly vulnerable. Give notice of returns to work. Prepare short-term plans regarding furlough, and factor in enough time to collectively consult if you need to change the terms and conditions or impose redundancies. And I'm now going to pass back over to Kirsty.
Thank you very much, Natalie. And thank you very much to everybody for the questions. We've had loads of questions in, so we'll get through as many as we can. If I'm not able to answer all of your questions over the course of the next few minutes, please forgive me, and we'll follow up in writing with you. So one of the first questions we had in was about parents who couldn't come back to work because of school closures. Are they entitled to remain on furlough until the end of October? Well, the simple answer to that is no, they're not. Nobody has a right to be on furlough. That you as the employer get to decide who goes on furlough. You need to get the your staff's agreement, but staff cannot insist that they remain on furlough. From a practical perspective, however, you may wish to agree to extend furlough if you can afford to do so. There is no reason why, to answer the second part of that question, you couldn't use unpaid leave such as parental leave or any other form of unpaid leave if the employee agrees, but you will need agreement to unpaid leave. If ultimately they won't agree to unpaid leave and they won't agree to return to work, then you could potentially look at dismissing them, but I would say take advice before doing so. The next question that came in was about collective agreements and trade unions refusing to hold meetings with their members via Zoom or telephone. How do you deal with that? Well, the starting point is to look at what your collective agreement says about your obligations to consult. But if the union is refusing to hold meetings, then I think all you can do as the employer is to give them the opportunity to participate in the consultation process, and then if they refuse, then go ahead in any event. You've given them a reasonable opportunity to participate. If they choose not to not to contact their members via Zoom or telephone, then you've done everything you can, and that shouldn't be a reason for holding up the process of consultation and getting staff back to work. Another question came in about public transport, and does the employer have to provide face masks for staff to use on public transport? Well, there is no simple answer to that question. I wish there were. From a practical perspective, I would say if staff don't have face masks and you are able to provide them, then you should do. Your general obligation as an employer is to provide any PPE that may be required actually in the workplace, which wouldn't extend to to travel to work. But given that the HSE guidance on risk assessments now says you should be considering risks in travelling to work, then you may well want to, if you've identified that there is a risk with people using public transport, you may wish to provide those. those masks. A question just come in about an employee who's on furlough, who is very clinically vulnerable, and who the employer thinks has had COVID-19. They want to return to work and have asked to do so. They tell us that their doctor says this is okay. How should you manage this situation? Well, I think probably you need to get medical advice on this, and I think it's reasonable for you to ask the employee to provide a letter from their doctor just saying that they are safe to return to work. I think also, as part of your COVID risk assessment that you're carrying out from a health and safety perspective, you should specifically address the question of people who are extremely clinically vulnerable, what the risks to them would be, whether they've had COVID or not. At the moment, the science seems to suggest that having had it doesn't prevent you necessarily from getting it again, although there's no firm view on that. The next question that came in was about compulsory tests for employees. Can we force employees to have tests? And I just want to link to that the question about test and trace, and can you force employees to tell you if they've been contacted by the test and trace service or not? My view is that it is reasonable for you as an employer to ask employees to have a test, and that it is reasonable for you as an employer to ask employees to tell you if they've been contacted by the test and trace service and told to stay at home self-isolating for 14 days, because they should not in those circumstances be coming into work. There are, however, data protection issues surrounding what you do with the data that you gather as part of the as part of any testing, because it will be sensitive personal data. And it will also, so you need to be careful when it's handled. So take specific data protection advice if you want to impose COVID testing in the workplace. In relation to test and trace, I think there is no idea why you could introduce a policy for staff to tell you if they've been contacted by the test and trace. What you may find is that people are reluctant to do so because unless you agree to top up their pay if they're self-isolating, they would only be entitled to SSP. So I'm conscious that there are a number of questions that we haven't been able to answer today. We will follow up with the people who have asked those questions directly. I very much hope you have found this session useful, and please do fill in the survey that has been posted in the Q&A section of the Teams meeting, and we will follow up with you and come back with any with answers to any unanswered questions. Finally, I would just like to say thank you for attending today. We have produced a huge amount of information about coronavirus and the legal implications, and if you go onto our website owenmitchell.com and search for the Coronavirus Hub, you will find a huge amount of information, FAQs on there, which hopefully will give you more information. Both Emily and I would be delighted to speak to you if you've got any specific questions that you would like to raise. If you have any suggestions for issues that you would like us to cover in future sessions, then please contact our events team at events@owenmitchell.com. We would welcome suggestions for further events. And I think that's it from me. So I just wanted to say finally, huge thank you for attending today. Please do fill in the feedback survey and stay safe and well. Thank you very much.